A very good evening to all. Welcome to the interview series of Verdictum, where we speak to the learned members of the legal community on various legal and contemporary issues. The intent behind this series is to give the correct insight to the people from the experts of this field. So today, we have with us Advocate Siddharth Batra, who will be sharing his views on the law of sedition. Welcome to Verdictum, sir.
Thank you.
So before we begin, let me give a short and brief introduction of Mr. Batra. So Siddharth Batra is an advocate on record and is practicing before the Supreme Court and Delhi High Court and various other courts and tribunal pan-India. Siddharth has over 10 years of experience in handling litigation and work assignments for various clients in the field of real estates, land acquisition, and dispute resolution. He deals with corporates across sectors including education, automobiles, manufacturing, or logistics. He also caters to several French companies and provides them with all legal support and advice. Siddharth's legal career began in 2005 when he was appointed as the Assistant Advocate General by the state of Haryana, and later in 2011 he became the Additional Advocate General. And additionally, he was also awarded the World by Business Legal World 40 Under 40 Award in the year 2020. So, with your permission, sir, should we begin the interview?
Yes, thank you, Sukriti, for the introduction. But I've put in 17 and a half years, I believe. It's not 10, it's 17 and a half by now.
That's great.
Yeah.
So, my first question is, since we are dealing with a very contemporary and a very sensitive topic, so the sedition law, which has been used from the British era till now, has always been a subject of debate in India. So, according to you, is sedition law required in India? And if yes, till what extent?
Look, this section 124A of the Indian Penal Code has been there since the British time. The British brought it at that point of time. And that point of time, the leaders who were involved, our leaders who were involved in the freedom struggle of India, the Britishers used that against them, the likes of Mahatma Gandhi and all those freedom fighters that we've had. Post that, the section has remained with us, but even the British have done away with it lately, long time back. The Americans did away with it somewhere in 1918. They brought it again, but then Supreme Court has clearly laid down a lot of guidelines for the freedom of speech and expression. And you know, US is a completely free country when it comes to freedom of expression and speech. As far as we are concerned, now this hue and cry about this law is being raised because you'll see last few years there have been a number of increase in cases under section 124A. What I've been told is that there's about 400 cases pending today, and till now there's only been conviction in 6. So that way prosecution has not been able to prove the guilt, and in many of the cases they've not been even able to file charge sheets. And for some other reasons, the law is being misused. Now, there's been a lot of debate onto the definition of sedition as such. Look, I'll make it very clear for your viewers that I am not in favor that it should be completely done away with. There are loopholes in the definition for sure. If you see the definition, it talks about disaffection towards the government as such. Now that disaffection may be a very varied definition, which is being completely misconstrued. This is being today used, I believe, to settle political scores. So in order to reply to what you have asked me, I do not think so that this section should be completely done away with. That's what the Attorney General also said before the Supreme Court. He expressed his views, and he later on made it clear that these are his personal views, and these are not the views of the government as such. And then, in fact, the union also has now filed an affidavit that they want to have a relook at the section itself. And they requested that the Supreme Court may not go into it at this point. And the Supreme Court has now adjourned the matter on the basis of the affidavit which has been filed by the Union of India. So I believe the section has to be there. I mean, there has to be some kind of fear if you're doing something against the state as such, against our country as such. But in the present scenario, the definition which is given is being completely misused. And there have been several instances. You can't just kill dissent by using a strong provision like Section 124. I think you can't kill dissent, and you can't kill the public opinion. And you can't inculcate fear in the minds of the people that ultimately, if you say something, then there'll be cases against you under Section 124A, which has happened lately. If you see that case of Disha Ravi, in fact, the toolkit case where Greta Thunberg retweeted what she gave. And ultimately, the police has not been able to give any evidence as to whether there was any such thing, what was alleged. And she was granted bail after 7 days. But what about that poor girl who stayed inside for 7 days for nothing, if you ask me? And that's a blotter, if you ask me. And what I'm a little disappointed is that once these false cases are registered and no substance is found, the officer who's maybe taking instructions from his or her political bosses, there's no action against them. There has to be some action at some point wherein somebody has to be made accountable. I know the definition is wide, it is being misused, but I am not saying that I'm completely in favor of the present definition as such, where it is defined. If you see the definition also of sedition, in the title sedition is written, but when you read the complete text, nowhere is the word sedition as such used. The definition needs to be changed for sure, and it needs to be that way narrowed down. And if there can be some guidelines coming from the Supreme Court or from the end of the government, those will be welcome. If we take the case of that cartoonist wherein he made a cartoon of one of our political figures, it may be funny. That person may think that's a little disrespectful, but that is not against nation as such. That is not against government as such. It's just an expression, right? So the expression needs to be protected. We are a democracy. We say we are the largest democracy in the world, right? And we have the largest number of youth in the country. So that kind of atmosphere which is being built, there has to be some confidence which has to be rebuilt in the minds of the citizens that, look, you have that freedom under Article 19, and that freedom can't be taken away by some misconstruction of a section which is there. So I think there has to be a provision to safeguard the interest of the country, but at the same time, this definition, I believe, needs a change for sure.
Indeed, sir. So my second question is connecting to the first one. That Section 124A of Indian Penal Code didn't undergo any major amendments, and though it has been demanded timely by the groups and it has been termed as draconian, the same law has been used by different political parties as an agenda which has been included in their manifestos as well. And now, since the government has also accepted that the major changes are requirement in this law, so is the law, according to you, is a necessity to curb the anti-national activities, or it actually demands or needs some major fundamental amendments? What are those fundamentals which has to be amended?
Look, as I said earlier, there's been a clear misuse. And if you see the definition, the misuse comes from the definition itself. The definition is that way very wide when it comes to it. Though if you read the provisos, it provides for the criticism of the government. It does provide for that. And that's where democracy is run on. If the citizens do not even have a right to criticize the government at the end of the day, how will that system of check and balances will work? Let's take an example of the farmer agitation that we have. It's, I think, one of the biggest agitations which I have seen during my lifetime in the country, where so many farmers sat around Delhi. There was so much of movement around the country. And there was at times some talk of some Khalistani movement or some foreign money coming in. Obviously, that has to be completely protected. I mean, we have to maintain the integrity of a country for sure. But at the same time, if there is no such aspect like that, and there is a genuine protest, there's a genuine protest against the action of the government, the farm bill may be the best thing, but ultimately it's the mandate of the government to convince the people of this country that, look, this is in your favor. And that protest or that criticism, if that is killed by using such section 124A, which is completely unfortunate, if you ask me. What I say is that the provision in itself needs a change because it made the definition very wide. Though I was reading views of Justice Lokur lately, he said anything that promotes hatred against the country as such should be termed as that. And if somebody is doing something against the sovereignty of the country. But if you see the definition as such, it is more wider than that. It brings into more. The word, I'll repeat again, uses the word disaffection. Disaffection is a very longer definition. But certainly, if you're criticizing the government, if you're calling a political figure a clown, maybe I can't be for that calling somebody a clown. I can't be charged under Section 124. There can't be cases for that. That fear has to go. And a lot of instances you will see that that is happening, right? And once that is happening, it's inculcating fears in the minds of everyone. That why do you want to say something in public or tweet something or be on social media, say all these things wherein there can be some cases against you. And you being an FIR being registered against a person under Section 124A, it's a non-bailable offense. And courts take their time, in fact, to grant bail. I mean, I repeat the case of Disha Ravi, 7 days in incarceration. I mean, a young lady who represents the youth of this country is very, very unfortunate. So the definition needs to be changed in order to make sure that that whatever an action of a person wherein it is you working against the integrity, against the sovereignty, against the interests as such, right? Obviously, that person can be brought to book. But when it's normal criticism or when there's dissent, because democracies work on dissent, then there's absolutely no case which can be made out under Section 124A. One more thing I have felt is that the police authority or the person official who's slapping such charges against, who's slapping such false cases against a person under Section 124A, which is so serious, has to be brought to book. And that is why there is a genuine demand for some guidelines to come up with. There have been guidelines which have been given by the Supreme Court at many stages. There have been guidelines in Vishakha's case. I think you must be knowing protection of women at workplace. And I think they've done absolutely well. I mean, a lot of all the organizations today are called upon to have committees to ensure that there's fairness and no women is exploited. So such kind of directions, maybe at some point of time, once the matter is reconsidered by the Supreme Court, once the matter is relooked by the union, maybe then the Supreme Court may on that place some guidelines as well to ensure that the misuse is stopped. So I'm completely against the misuse as such, if you ask me.
So my next question is related to the conviction rate in such cases, which has been very low, as has been pointed by the Honorable Chief Justice Ramana as well. So if you look at the data of the Home Ministry, so between the year 2014 to 2019, 326 cases has been registered, but only 6 convictions have been made. So what do you think is the major reason behind this low conviction rate on such a serious offense?
That poorly shows on the administration as such. That poorly shows on the police authorities which are registering such cases with absolutely no evidence. You can't just allege something on whims and fancies. There has to be some mechanism where you have to make sure that what you're alleging against somebody under section 124A has some grain of truth at the end of the day, is supported by some facts. It can't be just in the air that, as in the cases which have been highlighted recently, there's about 7 or 8 cases which have come up, which look to be more politically motivated as such. So that is why what prevailed upon, I believe, the Chief Justice to ultimately take cognizance of this matter and put Section 124A on hold. That's an order which has been passed. Though, in fact, the Prime Minister of India also has conveyed, has also expressed its concern about the law as such, that it came from the British time and there has been absolutely no change in that. In the affidavit also I was going through, it is written that the Prime Minister has taken the cue and has come up forward actually to see that whether this law should remain in the present form, and if at all it has to, then what has to be there, what kind of a definition has to be there. And coming back to your question, you're absolutely right. That's the reason why now Supreme Court has passed this order. I hope good sense will prevail at the end of the government to finally come up with something which really that way fortifies the confidence of a common man when it comes to our right, which is given by the Constitution, right to freedom of expression. It's as important as, if you ask me, the air I breathe, the water I drink. I mean, if I'm not allowed to say things which I wish to, under the parameters, obviously, which are not in any way which are not in any way affecting the integrity of the country or sovereignty as such, or are not that way against our country as such, right? I think I should have a right, and every citizen of this country should have a right for that.
So, don't you think that unlike the US or other Western countries, like given the special geopolitical situation India has, which has the adversarial neighborhood like China and Pakistan, who promote separatism inside India, it requires sedition law to ensure national integrity. And coming forward, the law which will come up or which will be revisited, should that be kept in mind while framing it?
I absolutely do not agree with that. If somebody is waging war against the country, like say China has been aggressor. Last 12 months, we've seen what China has been up to. Such difficult times as well of COVID, what we have seen. I do not think so. That's the reason to have the same section 124 that we have. Obviously, if somebody is being funded from outside, maybe China or some other international forces are funding something in India, right, to disturb the public order, to inculcate a feeling of hatred towards the government as such. If there are some external forces doing it, they obviously have to be brought to book, no doubt about it. But if you ask me, 124 is not the answer as such. And even the government is coming very hard on the NGOs as of now. But I don't see there's been any evidence which has connected any role from the side of China or Pakistan as such when it comes to all these statements where some people have been booked under section 124A. There's been absolutely no connection. And if at all there's a connection found, then obviously it makes out a case. You can't allow foreign forces obviously to interfere in our internal matters. I mean, you can't allow somebody to do that to our country as such. You can't allow international forces to have those kind of methods to create a public disorder in India. But I do not think so. 124A is the answer. We have a very, very popular government in the country with 300 member of parliaments, right? The government has its might to ultimately make sure that there is no such interference from any outside world. And at the same time, this government has to ensure that we, as the citizens, are able to exercise our rights as per the Constitution. So 124A, if you ask me, is not the answer.
Definitely. So recently in Supreme Court, several petitions have been filed to the abolition of the sedition law. In the matter pertaining to the Andhra Pradesh government registering FIR of sedition again two Telugu news channels, observe that in which Justice Chandrachud has always said that it is the time where we should define the limits of sedition. So what must be the limit in the law in your view?
As far as limit is concerned, look, I'll again repeat that the definition, if you ask me, is too wide to bring anyone. The proviso clearly provides that there can be a criticism of the measures or the reforms which are brought in by the government as such. But what is disaffection? What does disaffection include? Is hatred, enmity as such? That is too broad, if you ask me, which has to be ultimately curtailed. And in a way so that obviously somebody who's working against the interests of the country can be stopped. And we can't allow a free run to anybody like that. But at the same time, the freedom of expression, which there are instances wherein somebody posted a picture of one of the political persons who's occupying a high place in the government. That can't be sedition at all. Or maybe, for that matter, as there was a PL filed in the Supreme Court, as you mentioned, there was some PL filed wherein it was asked that there should be a case registered for sedition against Dr. Farooq Abdullah, for that matter, because he said he opposes Article 370. Opposition of Article 370, which is a law brought by the Parliament, passed by the Parliament, saying maybe he's a critique of Article 370. I don't think so. That makes a case of Section 124. One is free to have his or her opinions about a law which is brought in. And that's what the beauty of democracy is. And look, ultimately, how do you bring a government to book? How do you make the government accountable? What is the fair in the mind of the government? In India, we have a 5-year term. After every 5 years, the government goes to election. And it's public opinion on basis of which people vote out. And if the fallacies of the government are not pointed out, if the wrongs which are being done are not pointed out, are not brought into the public domain, what will happen? Will we go towards anarchy? You want people of this country to be just mute spectators as such? Obviously, I'm not saying that they can be just anybody can have a free go. No, not at all. Right? Obviously, somebody who's overreached, who's crossed that line has to be ultimately brought to book. But such instances on which cases are being slapped these days is completely out of the book. I do not think so. That was even the intent when the section was in fact drafted. That can't be the intent as such. Supreme Court also from 1964 case and not judgment has interpreted section 124 and said a lot of things. A lot of things have been said, but ultimately in practicality, whether those are being followed or not is the difficult problem that we have in hand. So once you talk about a change, I believe anybody being slapped with charges of section 124, I first think it has to maybe go through a very senior officer or some authority as such. But there has to be a proper case made out. And ultimately, if the case is not made out, and if it is found that it was for other motives, right? It was just to maybe harass the person, kill the dissent, and there has to be action to for the other side also. Who's done this? You can't allow those people who are doing it to go scot-free. Ultimately, every officer should have a responsibility as well. And it cannot be a political tool in the hands, right, to set scores. So yes, requires a change. The definition requires a change as well. But at the same time, the law, I'm not saying that you can absolutely do away with this law as such.
So coming on to our final question. So what are your final comments, suggestions, and provisions according to you must be added or removed by this law which fulfills the need of curbing the activities against the country, but also must not become a tool for the government to curb the voice of the people?
Look,
Any specific provision, any specific suggestion you have?
when you ask me this, I ask myself a question. In last 2 years, we've seen a rise in the cases. How many cases can you and me point out wherein allegations against a person under Section 124A are made out? As you yourself said, that many of the cases, the prosecution or the authorities are not even able to file charge sheets, meaning thereby nothing is found. It's not that easy to connect. I understand that there are sometimes some difficulties as well, but to bring this offense to book someone, you have to connect it. You have to connect it as to what the definition has been given as well. To my mind, the section needs overall change. It has to be made very, very specific. Number one, that it has to be only those actions wherein it can be made out that somebody wants to do it against the sovereignty and the integrity of the country, and as such not against the interests of the government. As such, wherein there is complete, wherein somebody wants to express kind of hatred towards the nation, right? That obviously somebody standing right in the middle of the city of Delhi burning the flag, obviously we can't allow that. I mean, if you ask me, that should be always brought to book, and that can be pardoned. Obviously, nation is first at the end of the day. Those people who with ulterior motives want make some statements which affect the integrity as such have to be brought to book. There are no two ways about it. But normal, simple expressions where people are not even crossing the line, right? You can't just slap cases on those people under Section 124. So 124 needs overall change. 124, if I have to couch 124, has to be made very, very specific that anybody making visible representations or anything that is prescribed in the definition, wherein it completely shows, it completely shows towards the fact that there is something which is against the country as such, right? Not that government, it's not that I express something about the government, I say something about the government, or I say something about the legislations which are brought in the government, I say something about what some officers are doing in the government. At the end of the day, all these political officers, all these political people, once they've taken the political plunge, you look at the definition of defamation as such, though that's a completely separate topic. Even the definition of defamation, in some of the cases, defamation is not even made out. Political leaders who takes a political one has to have some statements made by the public. Ultimately, those have to be tolerated because you've chosen such a profession where your actions will be ultimately seen by people, and they have a right to make their comments. They have their right to be critiqued. If not a critique of the government, who else will be? So that kind of wider definition which is there has to go. It has to be made very, very clear that criticism of the government as such, nobody will be liable for Section 124 or for sedition as such. So I think, and then maybe at some point there can be some guidelines as well, so that the heart of our democracy, that's the freedom to speech, can be protected.
Thank you so much, Mr. Batra, for your time. And we look forward to have more wonderful sessions on more contemporary topics with you. Thank you so much once again for being live with us at Verdictum. Thank you so much.
Thank you, Sukriti, and it's always good to see youngsters like you coming with such topics and giving us food for thought as well. And special thanks to Verdictum as well. I wish you I wish you success, and I wish that you do very well.
Thank you so much. Thank you.